Good morning. This is the time set for oral argument in 1 CA CV16 0318, Res AZ HP 160 versus GAMMAGE and Burnham et al. Each side is allotted 20 minutes for the argument. Appellant may reserve a time for rebuttal. If you wish to do that, counsel, you'll have to keep track of the time yourself using the podium at the clock. Out of respect for counsel, for those in attendance, I'll ask that you please turn your cell phones off or put them on vibrate. Counsel, I'd like to let you know that we have read the briefs in conference this case this morning. We encourage you to keep that in mind during your presentation. These proceedings are being recorded and will be posted to YouTube. So before you begin your argument, please state your name and the party you represent. With that, counsel for the appellant may proceed.
Good morning, Your Honors. My name is Brian Albu, and I represent the plaintiff below and the appellant here, Res AZ HP 160. This matter involves the ability of a creditor to be impaired from pursuing its claim because of a pending bankruptcy case. You will hear the defendants repeatedly use the phrase similar object and purpose, and that HP 160 is challenging the transactions the bankruptcy trustee is seeking to avoid. This conclusion is reached by the defendants improperly conflating and equating reliance on similar facts with similar object and purpose.
Well, counsel, help me here. Why aren't the claims in the state action that you've brought, to kind of use the buzzwords you're talking about, the same transaction or involved with a similar object and purpose as the claims that are brought in the federal bankruptcy court? Please help me.
Sure.
Kind of sort that one out.
Quite simply, we have 4 claims before the state court: fraud, conspiracy to commit fraud, aiding and abetting fraudulent transfer, and negligent misrepresentation. Those are not claims of the bankruptcy estate. The purpose of this policy is to allow the bulk of the creditors to realize on the recovery. So in order for there to be a similar object and purpose, the bankruptcy trustee must be able to assert our claims. The bankruptcy trustee has no ability to assert fraud against defendants, negligent misrepresentation. Aiding and abetting fraudulent transfer is a little different. There's specific case law on that which limits the bankruptcy court from allowing a trustee to pursue that. That's quite simply it. It's not an analysis of the facts. If we were to be pursuing the fraudulent transfer claims against the same defendants that the trustee is pursuing, then we would be, but we're not. So not only is the trustee unable to pursue the fraud claim, they're particularized to us, and that's brought up in the brief, that they don't impair the estate whatsoever. You could ask, this could be answered by one simple question. If we're allowed to proceed with our claims, how is the bankruptcy estate impacted? It's not. And the Bridge case is very instructive in this regard. First of all, it's from the 8th Circuit, applies Missouri law, and I don't think it would be the law is different here, for example, with conspiracy to commit fraudulent transfer. But the distinction there is very important. In that case, the bankruptcy court held that the party that instigated the fraudulent transfer, which in this case is defendants, that trustee had claims against that party. That third-party creditor, which would be us in that case, was interfering with that trustee's ability to settle those claims. So the Bridge case is very, very instructive and on point, but distinguishable because, unlike in Bridge, the bankruptcy trustee in this case does not have any claims against GAMMAGE and Burnham with which our claims interfere.
If the bankruptcy trustee succeeds in its claims in bankruptcy court, then that money would be for the benefit of all the creditors, right? Not any particular creditor, correct?
Yes, and that's at the cornerstone of the policy.
And that's not what we have here, right?
It is not what we have here because the bankruptcy trustee cannot, and the complaint the trustee has filed is in the record. There is not. The only claim against GAMMAGE and Burnham was conspiracy to commit fraudulent or aiding and abetting fraudulent transfer. That was dismissed, and that here is the critical distinction: is we can pursue our claims without interfering with the bankruptcy estate, and the bankruptcy estate has no competing claims. As I mentioned, the defendants contend that we are challenging transactions of the bankruptcy trustee, and as I just explained, we certainly are not. We're proceeding in a completely different manner. Under limited circumstances, a trustee can preempt the creditor's claims, but they're very limited. And again, the cornerstone of it must be that in order to preclude a creditor from pursuing claims, the trustee has to pursue those similar claims or substantially similar. For example, Judge Haynes here in the Hoyt case found that he wasn't sure whether or not a corporation could pierce its own veil. But he found that the debtor did have fraudulent transfer claims. So there you have the creditor being us going after the same recovery the trustee has, and that is simply not the case here. As I mentioned, the conspiracy to commit fraudulent transfer is a little bit different, and that arises the debtor can, or the trustee can pursue claims that the debtor owns. The debtor holds on the date of the petition. Clearly, the debtor could not have sued itself for fraud or any of these other claims that dated the petition. The conspiracy to commit fraudulent transfer is a little different, and the bankruptcy trustee has the ability to pursue its own avoidance claims, fraudulent transfer preference claims. It also has the ability to pursue fraudulent transfer claims under state law. However, that is under a very narrow statute, and there's controlling law in the Ninth Circuit that says the breadth of that statute does not include conspiracy to commit fraudulent transfers or aiding and abetting fraudulent transfers. Here we have controlling case law, right in this particular case. We have the bankruptcy court in the case that we're dealing with finding that the trustee doesn't have standing. And defendants, to get what the relief they got in state court, took the exact opposite position. Standing has to exist somewhere. You've already got a bankruptcy court saying it doesn't exist with me, and now we're deprived of pursuing that claim in the state court. In conclusion, this is a very, very harsh decision, if not cruel. We have a situation where we're deprived of pursuing our claims, yet the creditor base does not have the ability to do the same. We believe the decision is incorrect. It should be reversed. The case law has been misinterpreted. We set out the reason we have standing in our motion for summary judgment response to it and our appellate brief, and we believe the law is solidly on our side. It really eviscerates the policy behind having creditors benefit as a whole. There's no benefit for the estate for these claims that we've been deprived of pursuing for the time being.
But the claims were pursued initially in the bankruptcy proceeding?
What happened is the claim was filed in state court and removed by defendants to the bankruptcy court. We battled there regarding remand, and ultimately the case was remanded. So it started out as a Superior Court case, went to the bankruptcy court, and back again. We opposed the removal and prevailed on that issue. The issues come up as to whether or not we've waived collateral estoppel. We believe that whether it applies or not, the order of the bankruptcy court should be given preclusive effect because it deprives us of the ability to pursue a claim that the bankruptcy court already said could not be pursued in the bankruptcy court. Defendants were well aware of this order. It was attached to the motion for summary or response to motion for summary judgment. What wasn't clear at the time was whether it was a final order. This was an adversary proceeding with which we were not involved. Of course, we were monitoring it, and the decision to make it a final order came up in a subsequent amended complaint. So it wasn't even apparent from the initial order. So we believe that it should be considered collateral estoppel. The argument, whether we've waived the argument, is not jurisdictional. It's procedural, and it can be considered where appropriate. City of Tempe versus Fleming, cited in the materials. When we did realize that the order had become final, we immediately filed a supplement to our motion for new trial. We believe that the court below erred in not finding collateral estoppel. The argument that there's some kind of difference between the two is without merit. It's really two sides of the same coin. The finding of the bankruptcy trustee not having standing, the opposite applies. And again, it's a very harsh result. And we also think the court below erred in not letting the bankruptcy court decide or giving deference to the bankruptcy court's decision because it deprives us of the ability to pursue our claims. I'd like to reserve the rest of my time.
Thank you, Mr. Albu. Mr. King, you may proceed.
May it please the Court, William King for the appellees, GAMMAGE and BURNHAM, and Jim Palesi. Your Honors, this state court creditor suit is simply a rehash of the same fraudulent transfers and legal malpractice claims filed by the Chapter 7 trustee in the ongoing Koner bankruptcy proceeding. While HP 160's claims here do not share the exact elements of the trustee's claims in bankruptcy, each of them...
Well, then I guess that begs the question, when a creditor has an injury that is particularized to him or her, isn't that like a personal claim, or does it become really kind of somewhat their property, and it can only be asserted by them and can't be asserted by the trustee? I mean, this case afforded me the opportunity to read a number of federal bankruptcy cases, and I found that holding in several cases. How was that holding in those cases I read distinguishable from our case, I guess is my question to you.
Sure, Judge. So the basis of each of Rezaz's claims, or HP 160's claims, are that GAMMAGE and BURNHAM, by virtue of transmitting its client's verified financial statements, committed a fraud, made misrepresentations. That's at the front end of each of their 4 claims for relief. On the back end, and I should back up, to show causation and damages with respect to each of those misrepresentations, HP 160 has pled that it has to show the same fraudulent transfers that are at issue in the bankruptcy. So this isn't just, the representations were made only to HP 160, but that's only a sliver of the pie. If you look at the complete picture, the damages side of it, and I'll get further down into it, the object and purpose inquiry is injury specific. But the injury was an injury to the creditors as a whole, because a fraudulent transfer out of the debtor's estate affects all creditors, not just HP 160.
How do we get around the bankruptcy court's ruling that the trustee doesn't have standing to raise those claims?
That's a good question, and I'm happy to address it. What happened was the trustee filed a claim for conspiracy to commit fraudulent transfer under Section 544A of the Bankruptcy Code. GAMMAGE and BURNHAM moved to dismiss that claim on the basis that 544A did not provide the trustee standing. If you just stop it right there, HP 160's Catch-22 argument might have some merit. But that's not what happened. And in fact, what happened was after the dismissal of the conspiracy claim, the bankruptcy court granted the trustee leave to amend. And the trustee then filed a malpractice action against GAMMAGE and BURNHAM based upon the very same facts and alleging the very same damages that were at issue under the conspiracy claim.
Counsel, can't the same set of facts give rise to separate causes of action against other people or other entities?
Yes, of course, I agree that separate, the same group of facts can give rise to separate causes of action, but I think that starts to elevate, form over substance. The main argument that you've heard from HP 160 is, boy, as a result of this ruling from the bankruptcy court, nobody gets a benefit from pursuing GAMMAGE and BURNHAM. Nobody can go after GAMMAGE and BURNHAM for what it allegedly did. That's just simply wrong. The trustee filed an amended complaint. He sued GAMMAGE and BURNHAM for malpractice under the very same conspiracy facts and seeking the very same damages.
Isn't malpractice a different claim than this? It seems to be an individualized particular claim to this creditor. Seems different than a malpractice claim on behalf of the entire bankruptcy estate. Am I completely out in left field on that?
Well, the malpractice claim was brought by the trustee on behalf of the entire creditor, the entire body of creditors.
But if one creditor has some unique claim against against this third party, how does that change the relief that will be there for the rest of the creditors?
And that's when you get to the object and focus test, and that is an injury-specific test. So it's one thing for HP 160 to say, Gamage and Burnham made misrepresentations to us, and thus we were the only one damaged. But if you look beyond the misrepresentations, to make out a prima facie case with respect to each one of its 4 claims for relief, it has to show the same fraudulent transfers that are at issue in the bankruptcy case. Absent a challenge, a successful challenge to each of those transfers, it cannot prove causation or damages. And that's what brings it under the umbrella of the Bridge case. Under Bridge, which is from the Eastern District of Missouri, that claim involved creditor claims against a third party called Welsh Carson. Highland was the creditor in that claim, and Welsh Carson is similar to Gamage and Burnham in this claim. Just as the case here, the nature of Highland's complaint was that Welsh Carson made misrepresentations directly to Highland, which ultimately allowed time for the debtor Bridge to make fraudulent transfers to a third-party Savvis. The court in Bridge ruled that Highland did not have standing to assert its claims against Welsh Carson because its claims, regardless of the legal theories attached to them, amounted to a challenge of the pre-petition transfers at issue in the related bankruptcy proceeding there. Here, just like in Bridge, HP 160's alleged injury under each of its 4 claims for relief is identical to the focus of a fraudulent conveyance cause of action. And you need look no further than HP 160's First Amendment complaint for support. And I'll quote to you paragraph 284 of its complaint. Quote, HP 160 has suffered damages of at least the amount of approximately $1,759,000, which is the value of the assets transferred to the trust pursuant to the 2013 settlement agreement. Paragraph 280 is additionally instructive. Quote, HP 160 was damaged and deprived of the ability, ellipses, to set aside as fraudulent transfers or otherwise the undisclosed transactions that occurred during the forbearance period. Under each of its 4 claims for relief, HP 160 must make a successful challenge to each of the fraudulent transfers that are at issue in the Chapter 7's bankruptcy case. That's per its own allegations, and in fact, even below, it admitted that in opposition to Gamage and Burnham's summary judgment motion. Its admission was that the trustee's state court claims are necessary to prove causation and damages with respect to its misrepresentation claims and the predicate of its conspiracy to commit fraudulent transfer claim. I would urge the court to read Bridge or reread it if it has any issues about a particular injury versus an injury to the debtor's estate as a whole. And I would further point out that the facts of Bridge are really on point with our facts here. They involve a claim by a creditor against a third party, a non-transferee, based upon misrepresentations. But on the back end of each of those claims was the requirement that the plaintiff or the creditor prove the same fraudulent transfers that are at issue in the bankruptcy. I want to go back, if you will indulge me, and talk about the bankruptcy court's dismissal one more time, just because I think it's such an important issue. If the bankruptcy court would have ruled that the trustee could never recover the damages he sought under his conspiracy claim against Gamage and Burnham, then this catch-22 argument might hold water. But because in that instance, neither the trustee nor HP 160 could pursue Gamage and Burnham for its alleged involvement in this fraudulent scheme. But that's not what the bankruptcy court found, nor is that what in reality transpired. Specifically, following the bankruptcy court's dismissal of the trustee's conspiracy claim against Gamage and Burnham, which again merely found that the trustee didn't have standing under Section 544A of the Bankruptcy Code, the bankruptcy court granted the trustee leave to amend his complaint. The trustee filed a second amended complaint, which included a single count for legal malpractice against Gamage and Burnham. And critically, as I pointed out before, the trustee sought under his legal malpractice theory the same damages that he previously sought under his ill-fated conspiracy claim, and under the very same set of operative facts. G&B opposed and defended that suit, but ultimately, without admitting any liability, opted to settle the claim by payment of $600,000 to the trustee for the benefit of all creditors, including HP 160. That is where HP 160's remedy lies. And that makes eminent sense. Because the conspiracy claim seeks recovery of the very assets claimed by the trustee, not under the trustee's theory of conspiracy to defraud, but simple malpractice, and under virtually the same set and universe of facts, this is not the catch-22 situation that HP 160 so stridently urges. It is not a situation where, as HP 160 contends, it and the trustee are deprived of bringing a claim without any corresponding benefit to the estate. The trustee brought a legal malpractice claim. That claim was litigated. That claim was defended. But ultimately, Gamage and Burnham paid $600,000 to settle that claim. That is a direct corresponding.
That claim were the alleged misrepresentations unique to this plaintiff. Were those addressed during the
misrepresentations were a part of the trustee's complaint. The theory of malpractice against Gamage and Burnham was that Gamage and Burnham counseled its clients to commit fraudulent transfers or were actual participants in papering over these fraudulent transfers. So the fact that G&B made a settlement, paid money to the trustee for the benefit of all creditors, is a direct corresponding benefit to the entire creditor body. It is a benefit to the estate. We made this argument in our response, but rather than address this argument head-on in its reply, HP 160 continually overstates the effect of the bankruptcy court's ruling. And I quote from page 16 of its reply. HP 160 is subject to the extraordinary harsh remedy of being deprived of the right to pursue its claims. Yet, as the bankruptcy trustee has no standing to pursue the claims asserted by HP 160, there is no corresponding benefit to the creditors of the bankruptcy estate. That's simply not the case. They ignore the settlement. They ignore the trustee's legal malpractice claim arose out of the very same facts and prayed for the very same damages. That claim was settled, and that's where HP 160's remedy lies. I briefly do want to talk about the object and focus test, which is in Bridge in all of the cases that we've cited to this court, not one of which, by the way, HP 160 even brought to the court's attention below. There was an oral argument, and there was passing reference made to a few of these cases, but certainly no analysis. The appeal is really the first time I've seen any writing trying to distinguish any of those cases. And the attempts to distinguish those cases all fail. The first attempt is Razaz's argument that the cases we cited all involved claims against actual transferees or recipients of the fraudulently transferred assets. That was not the case in Bridge. I'd urge you to read Bridge. The case in Bridge, again, was a claim by creditor Highland against a group of partners called Welsh Carson. And the allegations are strikingly similar to the allegations that we have here. The creditor made misrepresentations, Welsh Carson made misrepresentations to the creditor. As a result of those misrepresentations, the creditor claimed that it was deprived of the right to really throw the debtor into bankruptcy. The same claims here. HP 160 alleges Gamage and Burnham made misrepresentations, and that as a result of those misrepresentations, it would have filed suit and it would have set aside the fraudulent transfers that are currently being pursued by the Chapter 7 trustee. Rupert and its progeny, and I'm going to talk briefly about this object and purpose. Rupert and its progeny, most notably the In re Bridge decision, made clear that when a bankruptcy trustee seeks to avoid a fraudulent transfer, which is exactly what we have here, individual creditors, just like HP 160, are barred from bringing any claim that shares a similar object and purpose. As articulated by the Fourth Circuit, a similar object and purpose exists when a creditor brings a state law challenge to a transaction that a bankruptcy trustee could avoid as a fraudulent conveyance. In that instance, the Fourth Circuit has held that, quote, the state law cause of action is so similar in object and purpose to the fraudulent conveyance claim that the creditor lacks standing to assert it. The Bridge Court is equally instructive on what an object and purpose means, and it says, and I quote, if a creditor's putative state law cause of action challenges the propriety of a pre-petition transfer because the debtor failed to receive adequate consideration, that cause of action belongs to the debtor's estate. HP 160 has alleged hundreds of allegations, damage allegations, in its complaint that challenge the very same pre-petition transfers that are at issue in the trustee's bankruptcy proceeding. HP 160 made those allegations, which are verbatim, if not nearly verbatim, from the trustee's complaint, because without them, it has no damages. If HP 160 could allege that, yes, GAMMAGE and BURNHAM made misrepresentations, and yes, we suffered an injury that no other creditor suffered, then we're not here today. It has standing to bring those claims. But it has not alleged any injury unique to it. The injury and the only injury it has alleged are the fraudulent transfers. That belongs in the bankruptcy court, and that is the claim that GAMMAGE and BURNHAM settled. A few points that I want to quickly go over. As I've already alluded to previously, HP 160 did not below cite, address, or discuss any of the authorities that GAMMAGE relied upon in procuring summary judgment. There was an oral argument. There was a transcript of that as part of the record. But if you go back and read that transcript, there's maybe a 30-second discussion of one or two of these cases. I don't believe that's sufficient to present the evidence to the trial court to give it a fair opportunity to issue its ruling. It's our position that those arguments...
You're suggesting there's a waiver by not citing to a case, though? Is that? I'm
suggesting there's a waiver from not even addressing the case. I mean, we cited 5 or 6, 7 cases in our motion, and in HP 160's response to the motion for summary judgment, there's nothing.
But if there's controlling United States Supreme Court authority that the parties don't cite, we don't look at that because they didn't cite it during an argument?
No, and your review is de novo, and you're allowed to look at, whatever you want to look at. It's just, I think what I'm trying to articulate is that HP 160 failed to provide the trial court sufficient information that it could make an informed ruling. And for it to get up here now and say that these cases don't apply, I think, is out of time. The collateral estoppel argument, there's one sentence. There's a one-sentence argument below that HP 160 made, and I'll quote it for you. Quote, if not afforded collateral estoppel effect or considered law of the case, significant consideration and deference should be given to the intent of the bankruptcy court, but the state court action should proceed to conclusion in this court. That's it. There's no statement of fact. There's no analysis. There's no citation to any authority. For those reasons, I believe that argument has been waived as well. But even if you want to look beyond the waiver, the issues have to be identical. The issues are certainly not identical. The issue in the bankruptcy court was whether the trustee had standing on a very narrow provision of the bankruptcy code, 544A, to bring his conspiracy claim. The issue here is whether Rez Az has standing in light of this federal body of cases that say if a creditor brings a state law cause of action that depends upon a successful challenge to a fraudulent transfer in bankruptcy, the creditor lacks standing to pursue it. I'm running out of time. Just if the court has any other questions for me, I'd be happy to answer them.
Thank you, Mr. King.
Thank you.
Mr. Armbruster, go ahead.
Thank you, Your Honor. Well, as I indicated initially, it's just a misapplication of the case law. This is not ownership of fact patterns. This is ownerships of claims.
Well, Mr. King made quite a bit of his argument was centered around the Bridge case. Tell me how that case is distinguishable and not applicable in our case.
Okay. I think it's very instructive. Initially, it's not from the circuit. And I think in the Ninth Circuit, the decision of the claims the trustee held would not be made, especially if conspiracy to commit fraudulent transfer. So there's a difference. But let's just assume the court correctly held the trustee has the right to bring these claims. This case is no different than any other one that's been cited, other than it goes after the instigator of the fraudulent transfers as opposed to the recipient. In the Bridge case, the trustee was trying to settle claims the court had found it had that were similar to the claims a creditor had. As illustrated in this case, we have claims for fraud, conspiracy to commit fraud, negligent misrepresentation against GAMMAGE and BURNHAM, the defendants. The trustee does not have those. They are not, the trustee doesn't, they're not his claims. And the malpractice raises a good point. There's a case where it is the debtors, because the debtor could have raised that claim when he filed bankruptcy. In that case, if we had some theory to pursue malpractice, I would agree. That's the trustee's claim, because the debtor could bring it. The debtor cannot bring the claim for fraud. The trustee hasn't brought one. So we not only have controlling law, but we have the complaint the trustee has brought. It doesn't assert a claim for fraud and the other related ones. Therefore, the Bridge situation.
I can say they're not related, though. The trustee did assert claims against GAMMAGE and BURNHAM that have now been settled.
Yes.
And presumably to your client's benefit in part as a creditor. How is that not related to the allegations you've raised?
Well, I think it's critically important to read the cases, because these are terms of art, and they have to be read within the confines of what these cases hold. And they are limited to the instance where you have a third-party creditor that is challenging, and that's an important word. It comes in a very narrow context. That we are challenging a claim the estate is bringing. So if we were to sue the recipients of the alleged fraudulent transfer, that would fit within a penumbra of what would be prescribed. But it's so critical that what defendants have done is simply carve out these quotes without looking at the entire fabric of the decision and the underlying policy. And that's really critical. You have to. This is a harsh remedy. And in order to exercise that, the bankruptcy estate must realize the benefit of those claims. There's been a suggestion, double dipping, but there's multiple tortfeasors here. We benefited from the malpractice settlement because we have a claim against the debtors. We aren't made whole by that. We have separate claims against defendants here that have no relation to the bankruptcy estate, and certainly we aren't challenging the fraudulent transfers. And I think the most persuasive evidence of that is you have the Ninth Circuit saying you are not precluded from proceeding with a conspiracy to commit fraudulent transfer. How can you not consider the fraudulent transfers under that ruling? That's fine. It's a misapplication to say we are challenging the fraudulent transfers within the scope of what we're talking about here. We are not pursuing the recipients of the fraudulent transfers. Therefore, we are not interfering with anything the bankruptcy estate has to claim.
So under your theory, every creditor could go after GAMMAGE and BURNHAM at the same time that the trustee is going after?
No, not at all. It depends what claim we're talking about. As to the fraud, negligent misrepresentation, and conspiracy to commit fraud, no, because we're the injured party. With regard to
that injury is just unique to HP 160.
Unique to HP 160. With regard to conspiracy to commit fraudulent transfer, that's an interesting one because that really is an exception where it's not particularized to us. But for whatever reason, well, for good reason, the bankruptcy courts have decided that the jurisdiction afforded under the Bankruptcy Code goes no further than the strict fraudulent transfer. With respect to that one, I would say that it's probably fair game for any creditor, but it's clearly not fair game for the bankruptcy trustee.
So, so your claim is that there were misrepresentations from GAMMAGE that were made specifically to your client, and that's the basis?
Yes, Your Honor, it is. And as a result,
And not any other creditor?
no other creditor. It was done in a settlement agreement. In 2012, I believe, they were financial statements provided to us, nobody else. Those claims are held by us and nobody else. The conspiracy to commit fraudulent transfer is different, but it's still clear that the bankruptcy trustee does not have the power to bring it. Therefore, it shouldn't be precluded because the bankruptcy can realize no benefit from it. And just to highlight that one of our cases does support this shared facts situation. Shared facts between third-party action and the debtor-creditor conflict do not in and of themselves suffice to make a third-party action related to the bankruptcy for purposes of bankruptcy jurisdiction. That's in the 7Cs Petroleum case at page 8 of our opening brief. Again, I don't understand what relevance the malpractice claim has. I think it just simply supports our position. It's a different claim. It's particular to the debtors. We wouldn't try to assert that. Yes, again, there's the same alleged misconduct, but I'm not sure what effect it had on any of our.
Not the same misconduct. You're saying that had to do with the fraudulent transfers as opposed to statements made during settlement negotiations?
The settlement agreement is not detailed enough. It provides for release, so I am not sure, what was contemplated in that. It resolved, as far as I know, resolved claims between the defendants and the bankruptcy estate for malpractice. Now, the fraudulent transfers is being asserted as a creditor claim under 544. In our response to motion for summary judgment, we did provide sufficient guidance for the Superior Court. Every one of these claims deals with an action where the third-party creditor is interfering with some action of the bankruptcy estate, and I mean direct, going after the same recovery, the same person. And these cases have to be reviewed in that context because they are terms of legal art used only in these cases. I think that the collateral estoppel issue, I think, was sufficiently raised too, because we knew that the court had granted a motion to deny a dismissal of the malpractice claim, but the court there found that it wasn't a final order. So we were reluctant. We suggested collateral estoppel, but we later found out that, in fact, there had been a motion for reconsideration that was denied, but buried in there was something that was declaring a final order. We immediately supplemented the record. We argued it was newly discovered evidence. Defendants didn't respond to that. So I think that's appropriately considered because as soon as we found out that there were additional proceedings in a matter in which we weren't involved, we immediately brought that to the court's attention. And I think also we did address these issues at the Superior Court sufficiently such that the court could make an informed decision. We went top to bottom of what it takes to preclude us from pursuing those claims. And the cases raised by defendants can be summarized in one sentence. We are not going after the same party for the same recovery. That covers every one of them, including Bridge. Every case defendants cite deals with fraudulent transfer, whether it's Rupert, Hoyt, Iverson, all are like that. The one little aberration is Bridge, but it's distinguishable because the court there found that the trustee had claims that were similar to the creditor. That does not exist here. The trustee does not have claims for fraud and the like. And I have nothing further unless the court has some questions.
Thank you, counsel.
Thank you very much.
Appreciate it. Counsel, thank you for your briefs and presentation today. The court does appreciate it. We will take the matter under advisement and issue a written order in due course. We will now be at recess and allow the next case to prepare for oral argument. Thank you.
Thank you.